the role of litigators. One thing people ask me a lot is, what's different now that you're on the bench? And one of the big differences is that I don't get to write the briefs, right? I'm dependent on the claims that the litigators bring, the facts that they establish at the top court level. You are the litigators, and your future litigators are the gatekeepers who decide what issues to highlight, which clients to represent, what causes our courts will address. And so you really are the key to justice, and you are the ones with the greatest impact. I also want to make two quick asks before I get in. I am going to talk about how our courts are being used to dismantle voting rights protections, but I want to suggest that that attention to judges and educating judges is potentially a role for the Thurgood Marshall Institute and for the legal academia more broadly. When I see sort of who's out there providing educational opportunities for state court judges, but also federal court judges, for trial judges and appellate judges, I see an imbalance. And so I think that I have certainly learned an incredible amount this morning. Some of it was really scary. And I say that also as someone who's got to run to keep my seat in 2 years. And the whole AI stuff is just way beyond anything I know how to cope with. But it's so important, and education about legal doctrine, like the current trends, like we don't have, as judges, like we don't have time to read all the law review articles that we should be reading, but bringing judges together and providing that kind of background and information for judges who are willing to come, I think could be a really important role. And the second thing I want to big picture urge you to consider and think about is how to have an inside and an outside strategy. I think most of what all of these discussions, and I'm focusing on litigation without intending to in any way disparage all the other tools that lawyers and advocacy communities have to address these issues. But whether you think of the inside and the outside as being, outside the courts, inside the courts, outside the system you're trying to address, inside the system, I think, I know I spent so much of my career trying to figure out how to impact things from the outside, that in 2016 and 2017, when I made the decision to, for the first time, run statewide, having never run for public office before, and to run for a seat on our state Supreme Court, it was a conscious choice to see, okay, what is it like to do voting rights as a candidate, right, from the partisan side, and what is it like to care about equal justice, and to, when I took that oath of office to serve as a justice on our Supreme Court, I swore to uphold the Constitution, which is what I thought I was doing as a lawyer, and so what does it mean to do that from the inside of the system, and what I've come away from that is very much the perspective of how important it is to have both of those strategies simultaneously, an inside and outside strategy. And to say a word about courts, I mean, for state courts in particular, there's a wide range of ways that people end up on state courts. North Carolina is not totally unique in the fact that we have partisan elections for our state courts. And particularly for our state Supreme Court, in recent history, that has meant there's incredible turnover. So if you think about the various institutions where you can do this work, whether it's federal courts, whether you're looking at legislatures, whether you're trying to petition an executive, whether that's the government, whether it's the president, state courts are actually a place that when there's elections, where can be pretty rapid turnover. When I was elected in 2018, sworn in January 2019. I joined a court that was 5 Democrats and 2 Republicans. I have now served under 3 different Chief Justices, and as of January 2023, the court has flipped to 5 Republicans and 2 Democrats, and I'm now second in seniority on the court, which kind of unreal, but a lot of quick turnover, which means that our courts are responsive to the voters because we are democratically elected by the voters. And so in thinking about having inside and outside strategies, think about where there can be rapid turnover, and so where there's the potential to have responsiveness in a democracy. So the main point of what I'm going to talk about is how our courts have been weaponized to dismantle voting rights protections. But I also want to focus on, and I'm definitely going to try to emphasize what, from my perspective, can be done about it. And finally, I want to say, I hope this can be something of a dialogue. So I hope you'll be thinking about your questions and not be shy about asking. Usually I'm the one asking the questions, but this is your turn to ask me questions. So in looking at what it means to say the courts have been dismantling voting rights protections, I do want to start with the positive vision of how I conceive what an equal right to vote really means. And here I'm borrowing really heavily from Lonnie Guinier, but from my perspective, there's 4 elements to an equal right to vote. So the first element is that every person has the equal right to cast a ballot that is counted. So all of the things around voter registration, photo ID, early voting, all of the issues about who gets access to the ballot are really that first level. We all should have the equal ability to cast a ballot and have it counted. The second level is that all the votes that are cast should count equally within the system. And so that's where redistricting, where one person, one vote concepts, where the aggregation of vote, you need a system that aggregates votes in a way that doesn't dilute the voting strength of some voters and unfairly enhance the voting strength of other voters. A partisan gerrymandering is actually an issue around whether all votes are counting equally. I would submit that racial gerrymandering is actually very different, and racial gerrymandering isn't a concept around the equal weighting of votes. In the racial gerrymandering cases, you don't have to prove that your voting strength is being diluted. You just have to prove that race was taken into account without justification in the redistricting process. But at any rate, second level, all votes count equally. The third level is that once you've got the right to vote, you've got your ballot, you cast it, it was counted, it's counted equally to everybody else's in the jurisdiction. The third level is that the people you elect should be able to serve on a level playing field. And my best example of this is a case out of Alabama, Presley versus Etowah County, decided by the US Supreme Court in 1992. And there the challenge was that the biggest thing that members of the Etowah County commissioners did was decide where roads go in the county. And as long as all of the members were elected at large, they were all white, roads were built in the white part of the county and not so much in the black part of the county. But any individual member of the county commission could decide where a road should be built. Once there was redistricting or Black voters started being able to register and vote, there became an African American on the Etowah County Commission, and they changed the rules. No longer could a single commissioner decide where the roads go. It had to be a majority vote, and there were still no roads in the Black community. And so that was actually challenged under Section 5 of the Voting Rights Act, the provision that no longer exists, but said that changes affecting voting have to be pre-cleared. And the US Supreme Court said this is not a change affecting voting. So they didn't buy the notion that an equal right to vote includes the right that the people you elect have an equal ability to serve. So I would make the argument as part of the right to vote, didn't carry the day in 1992 with Supreme Court. The fourth element, I think, is you've got your ballot, it counted equally, you elected your officials who serve on a level playing field. The fourth thing is that voters should have equal power to hold their elected officials accountable. because that's the final step, right? You not only elect people, but then you want to make sure that they're answerable to you in a representative democracy. And here I think some of the efforts around term limits, some of the efforts around campaign finance reform is not only about who can run and who gets elected, but also who can hold elected officials accountable. But I don't have a case that would stand for that. But that's kind of how I would lay out what an equal right to vote should look like, should include. So how have our courts been weaponized? Well, I want to start out with the proposition that this is nothing new, sadly. And there's a lot of folks who've covered this ground. If you've seen Levitsky and Ziblatt's book, Tyranny of the Minority, published last year, their entire chapter 3, which starts out with North Carolina, but then goes on to the rest of the country to really chronicle how the legal system was used to end the short window of experiment we had with multiracial democracy in the South in the Reconstruction era. So going through post-Reconstruction, how legal means were used to dismantle that. They point to Giles versus Harris, a 1903 case from the US Supreme Court that was a challenge to Alabama's voter registration system. The 1901 state constitution left only about 3,000 of 180,000 adult Black men in Alabama eligible vote. And the US Supreme Court said that they couldn't give relief to the plaintiff in that case because the allegations in the complaint were that the voter registration was fraudulent. And so if the court were to order that the plaintiffs be registered, they'd be participating in a fraudulent system. And beyond that, we don't have federal troops, there's no way to enforce it, so therefore we, Supreme Court, can do nothing about this problem. And that theme of we should not get involved because we can do nothing about it carries on through some of the more recent voting rights decisions, as I'll highlight. But you don't have to go all the way back to 1903. 1959, Lassiter versus Northampton County Board of Elections, a US Supreme Court case from North Carolina about whether or not the literacy test was a violation of the 14th Amendment in North Carolina. And the court said, no, even though the state literacy provision in the Constitution was enacted along with a grandfather clause. And even though the court had said way back in 1915 in Gwynn versus United States, that if they were both enacted together, they're so intertwined, if we find that the grandfather clause is unconstitutional, we must also find that the literacy clause is unconstitutional as contrary to the 14th Amendment. Even though that was 1915, by 1959, the US Supreme Court said, no, as long as everyone's required to take the literacy test, going to sort of have a blind eye to whether it's enforced equally, it's fine to have a literacy test. In Mobile versus Bolden, 1980, I would submit that was a decision by requiring that claims under Section 2 of the Voting Rights Act to prove vote dilution, that you had to show racially discriminatory intent. It wasn't enough to just show effect, that was a court trying to dismantle voting rights protections. And I just have to sneak in a victory because we have had some. Let me talk about Thornburg versus Jingles for just a minute. In 1986, so Mobile versus Bolden, 1980, said you have to show intent. Congress said, well, that's not what we meant at all. In 1982, they reauthorized and changed Section 2 of the Voting Rights Act to say, here's how you can prove a vote dilution. You don't have to prove discriminatory intent. And in the US Supreme Court in 1986, again, a case in North Carolina, set out the elements to prove vote dilution without proving discriminatory intent. So they eliminated the intent test. I started practicing voting rights in January of 1988, so shortly after that decision, and really I feel like it was like a couple of golden years of litigating voting rights cases. I remember vividly. So I practiced at one of the firms that was talked about earlier. LDF had cooperating attorneys. Julius Chambers' firm in Charlotte was one of those cooperating attorneys firms that I got to go to when I graduated from law school. And we were going around North Carolina. There were multiple local attorneys in South Carolina, Alabama, Georgia, Louisiana, throughout the South, bringing Section 2 Voting Rights Act cases, and we didn't even have to go to trial. We were settling those cases and ending the use of at-large election systems for school boards, county commissions, city councils. This is all documented in a book called Quiet Revolution in the South. And so while that blossoming of local, of Black elected office holders didn't happen only because of litigation, litigation did play a role. And for a few years, what I remember is going to the LDF Early Conference, and I would go every year. The employment discrimination attorneys would just be so frustrated because the courts were rolling back protections and employment discrimination. Housing discrimination lawyers were really frustrated. The school desegregation attorneys were just losing their cases. We were like, no, we're voting rights attorneys. we don't even have to go to trial. we just get the data on racially polarized voting. We show you can draw single member districts. We get a settlement because they don't want to pay our attorneys' fees. We win. So, there were a few good years, but then the rollback started. McGee versus Granville County, a Fourth Circuit case that said that you can't use alternative election systems, right? So we were beginning to show that maybe you couldn't draw 2 majority-minority districts, but if you used limited voting or cumulative voting, an alternative election method that allows a discrete but politically cohesive minority to elect their candidates of choice, that you ought to be able to impose that as a remedy instead. And the Fourth Circuit said no. That the jurisdiction can settle the case by using one of those alternative systems, but you can't bring a lawsuit and prove a violation by that you have to prove it using single member districts. And there's really nothing in the text of Section 2 of the Voting Rights Act that requires that outcome, but that's what the court said. We did settle a number of cases using limited voting in North Carolina. I know cumulative voting was used a lot in Texas, but to this day, there are Beaufort County Commission elected by a limited voting system that allows Black voters to continue electing their candidates of choice to that governing body, and they don't have to redraw, right? It's not a single member district system, so they don't have to redraw after every census. But we also saw limitations on the Section 2 test when the Fourth Circuit decided Lewis versus Alamance County, a 1996 decision that said, previously, when we were trying to prove a violation and showing that the voting strength of Black voters was being diluted, we looked at white versus Black elections and showed that voting was extremely racially polarized. But in Lewis versus Alamance County, they said, well, you also have to look at white versus white elections, which can totally skew the data, because if you have a white versus white election, Black voters have to vote for a white candidate if they're going to vote, because those are their only choices. So that narrowed the opportunities to use Section 2. And then through the Shaw versus Reno racial gerrymandering litigation, there became this rule that the borders of your demonstration district that you use to show that if we just use single member districts or use some alternative plan, you could empower Black voters, that had to be geographically compact. And that I would submit to you in the district court of opinion in particular, in Thornburg versus Jingles, it was the population that needed to be compact, not the shape of the district. But that, again, the need to have geographically regular shape boundaries of your demonstration district began to put a limit on Section 2. I could also talk historically about the limits on Section 5. Before we had it completely eliminated, there was Reno versus Bossier Parish, which went to the U.S. Supreme Court twice, but the second time, the U.S. Supreme Court said that Section 5 does not prohibit pre-clearance of a redistricting plan that has a discriminatory but non-retrogressive purpose. I know that sounds totally in the weeds, like only my voting rights nerds are with me right now. But take it from me. I apologize for being so professorial and in the doctrine. But that limited the opportunities to bring or to get objections under Section 5. And then, of course, in 2013 in Shelby County, the US Supreme Court decided that we don't need Section 5 anymore, or at least that Congress's reauthorization of it was not properly based on a current evaluation of the coverage formula. So I know I went through a lot of history, but just kind of wanted to say the courts have been used to limit our voting rights throughout history. And really, like lecture number 2 needs to be all the times we won and what were the conditions that led to those victories, because we really need to look at both. What are some of the current limitations? So you all are probably aware that last year in Arkansas State Conference of NAACP versus Arkansas Board of Apportionment, a federal court decided stunningly that there is no private right of action under Section 2 of the Voting Rights Act. That only the federal government can bring those claims, that private plaintiffs can't. And we'll see that opinion has already been criticized by some other federal courts, but an incredibly severe restriction. Remember I talked earlier about kind of the army of voting rights attorneys who, following Thornburg versus Jingles, went out and brought Section 2 cases across the South? Yes. The Civil Rights Division and the U.S. Department of Justice attorneys brought some of those cases. They still litigate some of those cases, but they cover the entire country. And their resources can't begin to match what all of the civil rights bar, whether you're looking at organizations like LDF, places like private firms like Ferguson Stein was, you can't even begin to match what that litigation resource meant. So if that precedent goes further, it'll be a severe limitation on the ability to ensure that this second level vote dilution is not happening. There have also been decisions that say Section 2 of the Voting Rights Act doesn't cover all elected positions. So a variety of elected positions, courts are saying, well, that's not really what Section 2 was meant to get at. Let me say a word about partisan gerrymandering and how that has rolled back our rights. I will divulge that I was engaged in or representing plaintiffs in the what became Rucho versus Common Cause, the 2019 decision of the U.S. Supreme Court, in which the court said that excessive partisan, I'm quoting now from that decision, excessive partisanship in districting leads to results that reasonably seem unjust. So the court is acknowledging partisan gerrymandering. It's reasonable to feel like partisan gerrymandering may not be fair, but going on. But the fact that such gerrymandering is incompatible with democratic principles does not mean that the solution lies with the federal judiciary. Our conclusion does not condone excessive partisan gerrymandering. Provisions in state statutes and state constitutions can provide standards and guidance for state courts to apply. So we have the U.S. Supreme Court saying, there's nothing we can do about, we understand that it's incompatible with democratic principles, but there's nothing we can do. So advocates took the court at its word and followed. So prior to this decision, there had been a decision of the Pennsylvania State Supreme Court finding that partisan gerrymandering violated the Pennsylvania Constitution. Following this decision in Rucho versus Common Cause, in cases that I was no longer involved with because I was on the bench, litigants brought a partisan gerrymandering claim in state court. And the North Carolina trial court, so they had to have a trial first, they put their evidence on, in a 258-page opinion. This is a trial court. Remember, these folks don't have clerks. They found that the 3-judge panel, and this is a unanimous panel, that the 2021 plans drawn in North Carolina constituted extreme partisan gerrymanders. And they found that, for example, the 2021 congressional plan was an intentional and effective pro-Republican partisan redistricting that all but guaranteed Republicans 10 out of 14 seats in a state that is a purple state. The trial court further found that the congressional map is even more carefully crafted to favor Republicans than at least 99 point, and they had 4 nines, 99.9999% of all possible maps using nonpartisan redistricting criteria. So these are, I'm reading to you from findings of fact of the trial court. The trial court concluded that this was not accidental. This was not driven by the geography of where voters live in the state. The 2021 congressional plan is a partisan outlier intentionally and carefully designed to maximize Republican advantage in North Carolina's congressional delegation. Trial court further explained that the legislative defendants offered no defense of the 2021 congressional plan. No expert witness opined that it was not the product of intentional partisan gerrymandering. I could read to you similar findings about the state legislative districts, both the state House districts and the state Senate districts. And so the trial court made those factual findings that in theory are binding on the appellate court. The first Supreme Court decision, state Supreme Court opinion in 2022 held that under our state constitution, the guarantees of free elections, equal protection, and freedom of speech. So also a First Amendment, or well, under our state constitution, an Article 1, but the freedom of speech guarantee in our state constitution all prohibit extreme partisan gerrymandering. And the opinion also sets out, that 2022 opinion sets out how you measure it. Right? A lot of the critique of whether or not you can find that partisan gerrymandering is unconstitutional is, well, we can't measure it. How much consideration of partisanship is too much? And just as we have something like 12 different measures of geographic compactness, and courts say, well, just look at some of them, we'll figure out whether it's compact or not. We said, here's 4 or 5 different measures of partisan asymmetry, of what is unfair in a partisan sense. Legislature, you decide which ones you want to use, but come up with a map that's fair to both parties. And importantly, that opinion did not say that, you know, it should be extreme partisan gerrymandering for the other party, right? It said, no, like if it's extreme by Democrats, that's going to be just as unconstitutional as extreme by Republicans. It was a statement that our state constitution, the notion that elections should be free, that there should be equal protection, and that the First Amendment rights of every voter in the state are not respected when their votes don't carry the same weight in the political process because of their political party, that it should be fair for everyone. In an unprecedented act of reopening a decision, and not only, like, we can talk about stare decisis, but we can also talk about law of the case. Right? Like isn't there a principle that once you establish a legal rule in a particular case, you're not supposed to change it later on in that same case? But in 2023, after the voters elected new members of the court, and the court flipped from a 4-3, 4 Democrat, 3 Republican, to a 5-2, 5 Republican, 2 Democrats, the new court allowed rehearing and reversed itself, and said that and they did not deny, they did not contest the trial court's findings. They didn't say, oh, you're wrong, this is not partisan gerrymandering. They said, we just don't have any power. There's under the state constitution, there's just no remedy for this. And so that is why we now have a prospect of using districts that will give one party a veto-proof majority in the legislature and totally flip the congressional delegation, even though the voters of our state vote roughly, you know, as I say, it's a state that went Democratic statewide, not only when in the presidential election, the first Obama election, but also in 2018. In 2018, the statewide Democratic candidates, we didn't have any Senate or statewide executive, like the governor wasn't on the ballot, but we had statewide officers, including members of the court, and that election went Democratic. So it is a state that is a swing state, but now has a legislature that is disproportionately and overwhelmingly Republican. So I want to just note that part of the impact of that is not only who's governing, but also the discouraging effect on voter engagement and voter participation, right? Because people feel like their vote won't matter, the system is rigged, and their voices will not be heard. And so we've worked really hard. When I say we, I'm putting my hat on now as a candidate and as someone in the political process, to encourage voters to especially pay attention to the statewide races, but also to not give up. And so, good turnout, and it's true, it has to be really good, but good turnout can defeat a bad gerrymander. And so we have to keep that in mind until we can get a system that's more fair. But I also want to talk about voter ID, because this is another arena where there's been long-term efforts in North Carolina to implement a voter ID provision, and I think that what the evidence ultimately shows is that this is kind of a modern day literacy test. So in terms of the litigation in North Carolina, a lawsuit was filed after, so we had a law passed that the governor wouldn't sign. Then Reverend Barber talked about some of this last night. Then in 2013, there was a voter ID requirement that was challenged in federal court. But ultimately, there was a constitutional amendment passed by the voters that required voter ID, but no details. So then after that, there's a state statute passed very quickly between the time that the legislature, elections in November and a new legislature being sworn in following those elections, a voter ID law was passed that was challenged in state court. And again, after a trial, the trial court found that the way in which voter ID was being implemented was intentionally racially discriminatory. And when that first came to our court for review, and the trial court applied the Arlington Heights factors, okay, but it was being evaluated under our state constitution equal protection guarantee. And we affirmed when I say we, the North Carolina Supreme Court in 2022 looked over what the trial court had done, looked at all the evidence they had considered, and said, yes, that evidence supports their findings of fact. They have properly applied the Arlington Heights factors, and we agree that that's the way you prove intentional racial discrimination under our state constitution, and we affirmed the trial court. And then again, unprecedented, same case, our court came back, the new court in 2023, and said, we're going to rehear this. Now understand that our court's been in existence for over 200 years, and this is the first time this has happened, that cases of this fundamental importance to the state's democracy are being reopened and reheard. You might think, well, okay, the next time we have a challenge, we'll look at it. But no, the case was allowed to be reheard. And in that rehearing, our court said that we're not going to use Arlington Heights as the standard to prove intentional racial discrimination under our state constitution. And why is that? The majority says that Arlington Heights framework is just too easy. It is too easy to prove. That statement is not with citations to the string side of all the times that Arlington Heights has actually successfully proved intentional racial discrimination. No, but it says, our court says that instead that we are going to apply a challenge that says to prevail on a facial challenge to a state statute under this state's traditional analytical framework, the challenger must prove beyond a reasonable doubt that one, the law was enacted with discriminatory intent on the part of the legislature, and two, the law actually produces a meaningful disparate impact along racial lines. We reached this determination not out of disagreement with the federal court's analysis of these issues under the federal Equal Protection Clause. Rather, we reached this decision because Arlington Heights' analytical framework is incompatible with our state constitution and this court's precedents, as it allows challengers to succeed on such claims by proffering evidence that by its very nature is speculative, subjective, and insufficient to meet our established burden of proof. So you might have thought that the federal constitution was a floor below which we can't sink, but apparently not always. This was a case that only had state constitutional claims, and you might have thought that our court actually swears to uphold the federal constitution as well as the state constitution, but not in this case. And so we now have a situation where voter ID was used in our recent primary election. And I will just tell you, you can watch the YouTube our oral arguments. The state came to us in the voter ID case on re-argument and said, this law, our voter ID law will not disenfranchise anyone. And we need it because there are some cases of fraud. Now, I think, as you know, voter ID only prohibits in-person voter fraud, right? There's other types of voter fraud involving absentee ballots and other ways, but it's only someone showing up and pretending to be someone they're not. And there might be 3 or 4 or let's say 10. Let's say there were 10 cases of impersonation that voter ID stopped prior to the enactment of this law. What we found in the primary that we just held was that 477 people who had to cast a provisional ballot because they didn't have an ID. Well, there were more that had to cast the ballot, but 477 of those ballots were not counted. That's out of 1.8 million voters. So the press coverage is like, oh, these numbers they don't seem striking. You all need to know that when Sherry Beasley, who was the first African-American woman appointed to be Chief Justice of our Supreme Court, in her election, she lost, there were 5.5 million voters. Okay, so in the primary, we only had 1.8 million. But back in 2020, 5.5 million voters, Sherry Beasley lost by 401 votes. So if we have 108 million voters and 477 votes are not counted, you know, I can't understand why you would say that these numbers do not seem striking as a voting rights attorney now. And understand, I'm not expressing any view on anything that might come before the court. I don't have facts about exactly where these voters lived or what I don't have the breakdown on the racial composition. I just know what's reported in the news. I'm giving you this was reported in the news, that 477 provisional ballots because of voter ID were not counted. And I think about those 477 people who got up in the morning and went to vote and wanted to exercise their right as citizens. I do not think there's evidence that they were all going and impersonating someone else, but their votes didn't count. And it troubles me. I don't understand why there's not outrage about that. If we'd had 477 people who really did commit in-person voter fraud, do you not think there'd be national news coverage about it? So that is a concerning development, and particularly troubling when we know that we're on the eve of a presidential election in the state. There are over 7 million eligible voters, and if out of 1.8 million votes, so many were not counted, it could be pivotal and very concerning. Let me say a quick word about, it was mentioned earlier, CSI versus Moore, Community Success Initiative versus Moore, was the case challenging North Carolina's provisions regarding how people with felony convictions can regain the right to vote. Again, a trial court had a trial. And I'll just say one other thing that's unfair about rejecting the Arlington Heights standard and then throwing out the plaintiff's claims is that we did not remand if the plaintiffs were operating under the theory that the way you prove racial discrimination is under Arlington Heights, and we're now going to change the theory, shouldn't we remand to allow them to see if that evidence actually fits the new theory that we have, or if there's other evidence that would fit the new theory? We did not do that. And we did not do that in CSI versus Moore. So same process, plaintiffs challenged it. They brought forward the legislative history of North Carolina's provisions. A trial court looked at all that evidence after a week or more long trial. There were expert witness testimony. The trial court found that our provisions were enacted with the intent to discriminate against Black voters in the state, and ruled that they were therefore unconstitutional under the state constitution. This time, we didn't actually hear the appeal until after the election, so it wasn't quite as egregious in the sense that it wasn't reopening a case that had been decided. But on appeal, the majority in 2023 held that Arlington Heights is not the standard. The evidence does not prove that it's intentionally racially discriminatory. So people who previously were able to vote are no longer able to vote in North Carolina, people with felony convictions. And there's no opportunity for them to go back and show under the new standard. And let me just put one other case that I want to call your attention to, because I think it illustrates how we wrestle with legal doctrines and the structure of our democracy. And that's a case called NAACP versus Moore. Again, North Carolina State Court, the NAACP challenged the legislature's decision to put on the ballot a constitutional amendment when the legislature that made that decision was elected under racially gerrymandered districts. And not just one racially gerrymandered districts, but a whole bunch of racially gerrymandered districts. So it kind of raised the question, if you've proven that a legislative body is unconstitutionally constituted, do they have the power to change the structure, put in place constitutional amendments? Do they have the power to make such far-reaching decisions? And a majority of the court in NAACP versus Moore put forth some pretty rigorous standards to answer that question. And in a situation where it really hasn't come up very often or been ruled on before. We'll see whether that precedent stands, but that is, I draw that to your attention as another case looking at the issue of how does our legal doctrine deal with these structural problems in our democracy. So I want to suggest to you, and here, this is a new thing too for me as a litigator. I didn't have to worry quite so much about judicial philosophy, but now when you run for office, people want to know, what is your judicial philosophy? And what I feel so strongly is that originalism, which is a common one that lots of people like to talk about, is fundamentally incompatible with democracy, okay? Because originalism says, what did those people who originally passed the Constitution say about how we should be governed? And democracy is supposed to be about the people who are being governed deciding how they want to be governed. And even if you read some of the Federalist Papers, they debated whether current generations could bind future generations. And there's certainly some need for stability and some need for balance. But I think that if you believe in the proposition that democracy means that the people who are being governed have a voice, have a say in the people who are making decisions that impact their lives, that should also apply to the concepts that we have about how our democracy should be constituted. And it seems to me, as I was listening to and I've thought this before, but I was listening to discussion about felon disenfranchisement and how reenactment of an initially intentionally racially discriminatory measure cleanses it of that racial discrimination. I'm like, well, what about originalism? Like why shouldn't we, if the original intent matters, why do we get to cleanse it by reenacting it? But with our other constitutional guarantees, we don't get any cleansing, apparently. And I'm not trying to be facetious. I'm actually really saying that these things matter, and that you all in the academy can help us sort through and perhaps come up with better ways of understanding what it is we are about when we are doing voting rights work and when we are saying, here are the laws that govern how our democracy is structured. So I promised to talk about what we can do about it, and here are my 5 things you can do. Because, and here I'm actually not talking strategy, I'm talking about the 5 roles that I see lawyers can have. The first is a watchdog and a whistleblower. Sometimes, even if you can't win in court, if you can't get the legislature to adopt your changes, if you can't have an impact at the local level, you can actually change things by making clear what's going on, by being a watchdog, by being a whistleblower. And sometimes it takes a lot of courage to do that, because what you say and what you're shining a light on are things that people don't want you to be talking about and don't want you to be bringing to light. So that I put that's number 1. Number 2, don't underestimate your roles as influencers and thought leaders. You can make clear what our justice system should provide and what equal justice under the law really should mean. And so as a political candidate, a lot of the campaign ads, the attack ads on me were about, crime, right? If you lock them up, you're good. If you don't lock them up, you're bad. Is that really all our justice system is supposed to provide? As lawyers, you can help people understand that the protection of our fundamental rights is also a really important function of our justice system and ought to be a way that we are holding our judges accountable. Third thing, obviously, you can be advocates for your clients and communities for institutional change. That's the level we've all been talking about. Fourth, I want to talk about allyship, because that's different from advocacy. And I feel like I didn't pay enough attention to that when I was a litigator. But the ways in which, I understand my community and the things that affect me personally and directly, but there are other issues where I can be an ally, and developing that skill and being a good ally seems to me something really important for lawyers to do. And finally, you can be an organizer and a catalyst for change, and you can do all 5 of these things at once, or you can focus on some. But I think it's important to have that broader vision of what your skill set enables you to do and how you can have an impact. And finally, before I stop and ask for questions, let me suggest, as we're envisioning what an equal right to vote means, where would I say, so now I'm talking substance, where would I suggest you go next? I really do think looking at more proportional representation systems is really important. That the winner take all, and again, here I'm leaning heavily on Lonnie Guinier, but the winner take all systems devalue more votes than we need to, and that if we had more proportional representation systems, we'd have more people feeling like they have a stake in our democracy and that their vote really mattered. The second thing I'll suggest, and this I think can be done at the state level, but also at the federal level, and I'm not meaning to ignore the federal legislation that's been proposed and already discussed, but I think having Section 5 was kind of like having a racial impact statement. Right, like, we have environmental impact statements. We should have racial impact statements for any of our election methods, and it should be nationwide. We don't need to just focus one place. That I think could really help us get to where we need to be in terms of having a multiracial democracy. So let me just close with this. I used to describe my career, my litigating career, as, I was defending the gains that those who came before me achieved. I came right after Thornburg versus Jingles. I worked with Julius Chambers' firm. They had done what I wanted to do when I grew up as a lawyer, right? They had gone to court, they had won these cases, they had expanded the law, they had opened up opportunities, they'd broken down barriers. That's what I wanted to do. And actually, my career was trying to defend their gains and not very successfully. But lately, I have realized that that glorious vision of what they were all doing and what they'd all achieved, actually, no, they had setbacks. There were times when the court was, used to restrict voting rights, and that I'm actually engaged in the same enterprise that those who came before me and those who I wanted so much to be like, and that is just the struggle. That is just the fight. And I am thrilled that all of you are here today and that you are eager to be enlisted in that struggle and fight, because that is what it will take to save our democracy. So, thank you.
We have time for a couple of questions. You have a question? You can start the question. I'm bringing.
Thank you, Justice Earls, for coming today. My question has to do with, has to do with North Carolina and y'all's partisan court. Of course, North Carolina is not the only state with the partisan court. I think of Alabama, I think of Wisconsin. But do you think that the partisan court had something to do, or I guess I should say, would the result be different if North Carolina did not have a partisan court when it comes to the partisan gerrymandering cases and the voter ID cases?
So if by partisan court you mean a court elected in partisan elections?
Yes.
I think I sort of feel like that's an interesting philosophical debate. Like, how much does the method of how people get on the court impact ultimately how that court behaves? And that I don't have, like, I feel like I'm not qualified to answer that question because I'm not a political scientist who's looked at all the data. What I do think is that courts are not operating in a vacuum, right? So if we have an incredibly divided partisan electorate, public, and culture, it's going to influence courts. When I was doing voting rights work, we pretty much consistently figured we could look at the party identification of the judges and figure out how they're likely to rule, but not entirely. And so in the initial partisan gerrymandering, in Common Cause, what became Common Cause versus Rucho, the 3-judge panel included a Republican who voted with the Democrats. So it's not a perfect predictor. So party affiliation isn't a perfect predictor of how you're going to rule. I feel the bigger issue, the bigger influence is not how you got on the court, but two things. So you know, we talk a lot about guardrails, but I feel like we can have, this is another thing like that I feel really strongly after serving on the court that I would have never guessed in the years I was litigating. And that is that we can put in place all the structures we want to try to get fair, impartial, get a justice system that lives up to all of our ideals. And at the end of the day, it depends on the integrity of the people who serve. And so structure matters, and I'm not trying to say you shouldn't pay attention to it, but what people are willing to do in those leadership roles and what integrity they have is a huge important factor. So I kind of want to say it wouldn't have mattered. And interestingly, so it's integrity, but it's also court culture. So I've talked to a lot of justices on other state Supreme Courts, and it's really interesting to get their perspectives on what their courts are like. And there's some really important differences in state Supreme Courts, in their court culture, how they operate, how they interact with each other, how they view what they're doing. And some of that can be possibly structure influenced, but it's bigger than that and not that simple. Sorry.
I have one more question.
We're unfortunately right at time. I'm so sorry. Potentially the justice can stay for a few minutes afterwards. We do have to stop, but please join me in thanking Justice Earls for a fantastic lecture. Thank you so much for joining us this afternoon. We welcome you to stay for our final panel that will begin in 10 minutes, and we'll reconvene in this room. There are snacks for those that are continuing to participate.